can if you would like. And then after I read the jury charges, then I'm going to recess you for lunch, and then you can come back and begin deliberating. We'll have all the evidence back in the jury room. Okay? You are considering the case of the State of Georgia versus Miles Bryant. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false report of a crime. The indictment reads as follows. In the case of 24B 00156-4, State of Georgia versus Miles Bryant, bill of indictment, count 1. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charged and accused Miles Bryant with the offense of malice murder for the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury, did unlawfully, with malice aforethought, cause the death of Susana Morales, a human being, in a manner unknown to the grand jury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. The grand jurors aforesaid in the name and behalf of citizens of Georgia charged and accused Miles Bryant with the offense of felony murder for the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury while in the commission of the offense of kidnapping, a felony, did cause the death of Susana Morales, a human being, in a manner unknown to the grand jury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charged and accused Miles Bryant with the offense of kidnapping for the said accused in the county and state aforesaid on the 26th day of July 2022 did unlawfully abduct and steal away Susana Morales without lawful authority or warrant and held such person against her will, said act resulting in bodily injury to Susana Morales, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. The grand jurors aforesaid, in the name and behalf of the citizens of Georgia, charge and accuse Miles Bryant with the offense of criminal attempt to commit rape for the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury, did knowingly and intentionally attempt to commit the crime of rape in that the said accused had kidnapped Susana Morales, an act which constitutes a substantial step toward the commission of said crime, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse Miles Bryant with the offense of false report of a crime for the said accused in the county and state aforesaid on the 27th day of July 2022 did willfully and knowingly give a false report of the crime of theft by taking to William Merkley, a law enforcement officer with the Gwinnett County Police Department, contrary to the laws of said state, the good order, peace, and dignity thereof. Dates immaterial. The indictment in this case does not state that the date of the offense is a material averment or element. Therefore, it is sufficient that the state show that the offense occurred prior to the filing of the indictment, regardless of the date listed in the indictment. Issue and plea of not guilty. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize the conviction of the defendant. Jury, judges of law and facts. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is a means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into the court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, The true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. Credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Expert witness. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon their training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Witness attacked. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to attack, cast doubt upon, or challenge the credibility or believability of, or cause you to disbelieve any such witness. This would include evidence of proof that the witness has been convicted of the offenses of escape, aggravated assault on a peace officer, theft by receiving, theft by taking, interference with government property, burglary, and possession of a firearm by a convicted felon. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statement and testimony when compared to the same witness's trial testimony. As with all issues of witnesses' credibility, the jury must apply your common sense and reason to decide what testimony you believe or do not believe. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness provided you find the evidence to be sufficient. Defendant's choice not to testify. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Statement of the defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent defendant was informed of his or her rights as discussed below, if applicable. Circumstances of a statement. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. Burden of proof as to rights. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Conditions precedent to consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict except for purposes of attacking the credibility of the witness or impeachment. Constitutional rights. If you find that the statement was made while in custody and a result of police questioning, you must also determine whether the defendant was advised of his or her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that the law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1. The defendant had a right to remain silent. 2. The defendant chose not to remain silent. Anything he said, wrote, or signed could be used as evidence against the defendant in court. 3. The defendant had a right to consult a lawyer before any questioning and to have a lawyer present with him at all times during any questioning. And 4. If the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. Burden of proof as to rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given and they were understood and knowingly given up by the defendant. Other crimes, wrongs, or acts. Sometimes evidence is admitted for a limited purpose or against some parties and not others. Such evidence may be considered by the jury for the sole issue or purpose against that party for which the evidence is limited and not for any other purpose. In order to prove its case, the state must show intent. The state has offered evidence of other acts allegedly committed by the accused to prove intent and motive and negate any defenses of accident or mistake. To do so, the state has offered evidence of other crimes, wrongs, or acts allegedly committed by the accused. You are permitted to consider that evidence only insofar as it may relate to that issue and not for any other purpose. You may not infer from such evidence that the defendant is of a character that would commit such crimes. The evidence may be considered only to the extent that it may show the elements or issues that the state is required to prove in the crimes charged in counts 1, counts 2, counts 3, and count 4 in the case now on trial. Such evidence, if any, may not be considered by you for any other purpose. Before you may consider any other alleged acts for the limited purpose stated, you must first determine whether it is more likely than not that the accused committed the other alleged acts. If so, you must then determine whether the act shed any light on the elements of the offenses or issues for which the acts were admitted in this crime, in the crimes charged in this indictment, in this trial. Remember to keep in mind the limited use and the prohibited use of this evidence about other acts of the defendant. By giving this instruction, the court in no way suggests to you that the defendant has or has not committed any other acts, nor whether such acts, if committed, prove anything. This is solely a matter for your determination. Identification and reliability. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all the factors previously charged you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: Number 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. 3, the possibility of mistaken identity. 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator. And number 6, the length of time between the crime and the out-of-court identification. Identification burden of proof. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as a perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of this defendant as the person who committed the crime alleged in the bill of indictment. Definition of crime. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by statute. No presumption of criminal intent. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumptions and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge. Knowledge on the part of the defendant that the crimes of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false report of a crime were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that the crimes were being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of alleged offenses, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false reporting of a crime being committed, and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. Guilt by mere presence. A jury is not authorized to find a person who was merely present at the scene of a commission of a crime at the time of its perpetration. Excuse me. Let me start again. Guilty by mere presence. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Venue. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution, in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. Required use of conjunctive language in indictment. When a defendant is charged with the violation of a penal statute containing the disjunctive or separating several ways or methods of a crime may be committed, the indictment must charge such ways or methods with the conjunctive and, if it charges more than one of them. Accordingly, at trial on such an indictment, it is sufficient that the state prove any one way or method of commission of the crime beyond a reasonable doubt, and the state is not required to prove all such separate ways or methods alleged in the indictment. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Offenses charged. Malice murder. For malice murder, the state must prove that the defendant, number one, caused the death of another person, number two, unlawfully, and number three, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandonment and malignant heart. Abandoned in a malignant heart, excuse me. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do so, that is enough for the killing to be murder. Felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Kidnapping is a felony. I will define kidnapping for you shortly. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the kidnapping, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Kidnapping. For kidnapping, the state must prove that the defendant, number one, abducted another person, number two, without lawful authority or warrant, number three, held that person against her will, and number four, that the person was physically injured. To constitute kidnapping, the abduction must involve moving the alleged victim. That movement can be slight, so long as it is not merely incidental to another crime. Movement is not merely incidental to another crime if it conceals or isolates the alleged victim, makes it substantially easier to commit the other crime, lessens the risk of detection, or is done to avoid arrest. The injury may be minor, but it must have occurred during the kidnapping. It does not matter if the injury occurred at the beginning of the kidnapping or after the person was abducted. Criminal attempt to commit rape. A person commits criminal attempt to commit rape when, with intent to commit rape, that person performs an act that constitutes a substantial step toward the commission of the crime of rape. For rape, the state must prove the defendant had, number one, carnal knowledge, number two, of a female, number three, forcibly, and number four, against her will. Carnal knowledge means sexual intercourse, which is any penetration, no matter how slight, of the female sex organ by the defendant's male sex organ. Force means acts of physical force, threats of harm, or intimidation. Against her will means without her consent. False report of a crime. A person commits false report of a crime when the person willfully and knowingly gives or causes a false report of a crime to be given to any law enforcement officer or agency. This court has no interest in this case. By no ruling or comment that this court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. Sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. Deliberations. One of your first duties in the jury room will be to select one of your number to act as foreperson. The foreperson will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. Verdict generally. You will have a verdict form with you in the jury deliberation room. If, after considering the testimony and evidence presented to you together with the charge of this court, you should find and believe beyond a reasonable doubt as to count one that the defendant Miles Bryant in Gwinnett County, Georgia, did on or about July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of malice murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of malice murder, or if you have reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 2 that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of felony murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of felony murder, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of this court, you should find and believe beyond a reasonable doubt as to count 3 that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of kidnapping as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of kidnapping, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 4 that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of criminal attempt to commit rape as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of criminal attempt to commit rape, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count 5 that the defendant Miles Bryant in Gwinnett County, Georgia, did on or about July 27, 2022, commit the offense of false report of a crime as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of false report of a crime, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Unanimous verdict. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Any jury communication to the court from this point forward must be in writing. The parties must be informed of the content, and the writing must be marked as an exhibit and entered into the record. The court must allow counsel to suggest appropriate responses. The court must inform counsel of intended response of the court. The court must allow opportunity for counsel to respond. Again, you will have a verdict form with you, and after you return from lunch, you may retire to the jury room, but I don't want you to begin your deliberations until you return to the jury room, receive the indictment and any evidence that's been admitted in this case. Does the state have any objections to the reading of the jury charges?
Judge, may we approach?